Testing Justice 7. Testing Justice 6. Testing Justice 5. Doesn't sound very loud. Testing Justice 4. Testing Justice 3. Testing Justice 2. Testing Lavalier 2. Testing Lavalier 1.
Matter before the court is Sentence Review Panel, docket number 24198, State versus Jason Servil. We are being streamed on the web, both by video and by audio. If counsel would identify themselves by saying their names for the record, together with the party they represent, starting with appellant.
Jeremy Pratt on behalf of the appellant, Jason Servil.
Katie Sibley on behalf of the state.
Thank you. Counsel, if you're ready to proceed, we'd be happy to hear your argument.
Chief Justice, members of the court. Maine Code of Judicial Conduct Rule 2.9c states, and I quote, "A judge shall not investigate facts in a matter independently and shall consider only the evidence presented in any facts that may properly be judicially noticed."
Counsel, I see that the green light is on. I appreciate that the Code of Judicial Conduct says that, but is that a rule of law for criminal sentencing?
No, but I think it's appropriate for the court to recognize that it would violate a judicial canon, and I just thought it would be an appropriate place to start as a basis for understanding what happened in this case. The sentencing court began by investigating, I should strike began, I don't know why I said that, investigated independently and found a obituary of the victim in this case. And
Was there a fact within the obituary that was not all included in other material that was properly in front of the court?
I think I wouldn't be able to point out on the top of my head a specific fact that was not previously in front of the court.
If the court did investigate outside the four corners of the evidence in the courtroom and use it as part of a judicial proceeding, does that ipso facto constitute obvious error that requires a reversal, or do you have to show some level of prejudice that it upset the course of the proceeding somehow?
We would like to, for this court to find that ipso facto, it requires...
And you objected immediately, as immediately as you could afterwards.
There was some interruption for me not to be able to. But the reason that we think is it gives the appearance of bias, which is just as important as bias itself. The sentencing judge did not choose to independently investigate for the benefit of both sides. He only independently investigated for the benefit of one side.
So, counsel, so I'm clear. It's not the facts themselves?
No.
Because a family member could have gotten up and read that obituary.
That's correct. It's not the facts themselves. It's the conduct of the judge that diminishes the confidence in the independence and impartiality of the judicial branch by a judge engaging in investigations for one party and not for both parties. As a defense attorney and with a defendant there, we cannot help but think that the judge is already predisposed to be favorable to the other party. I think the public will think that. I think it undermines the confidence in this proceeding and overall undermines the confidence in the judiciary. That the court should take into account public confidence when determining what is appropriate conduct by a judge.
But trial judges in sentencings like these in particular frequently will quote passages or will bring in external information, maybe not in the course of the sentence itself, but as part of an effort to, bring some dignity and some closure to the family. So you're not suggesting that a trial judge, a sentencing judge, can't ever bring in any kind of external material, are you?
I think it depends on when in the sentencing process it takes place. I think it would be inappropriate for really anything to take place in step 2 of the Huey analysis that has been independently researched. I think if you're talking about sort of the closing remarks, that is something to help give closure, to help give a feeling of frankly, compassion, that it would be appropriate.
Such as the psalm was read here.
The psalm is I think in a different category because we have a pretty, hopefully, strict establishment clause of the separation between religion and...
But putting that issue aside, the point in the proceeding at which the psalm was read is different, is what you're saying, than the point in the proceeding at which the judge brought in the obituary.
Correct.
But if we're looking at the overall appearance, which is, I think, the focus of your argument, in terms of the sentence that was imposed, there was no life, there was no consecutive sentence, so there was no actual evidence of any kind of leaning towards a particular side, was there?
I don't know, because absent that, I don't know what this judge would have done absent his independent research of what the sentence he may or may not have imposed.
How much did you ask for in the sentence?
I asked for consecutive sentences. If the court recalls, my third argument was that the two sentences should be consecutive.
But what did you ask for the sentence on the murder charge?
I believe I asked for 35 years.
And, okay.
With a 10-year consecutive, fully suspended sentence on the other one.
So let me ask you this, going to that argument. If we were to reverse the sentence in this case, one of the principles is that on resentencing, a defendant cannot be sentenced to a greater sentence. So your appeal that there ought to be able to be a consecutive sentence seems to run afoul of that.
Well, no, because we're asking, the overall sentence would still be the same amount of time. It would just be structured differently. I mean, that was the thrust of my argument at the lower court.
I understand it was the thrust of your argument, but if we are to flip the sentence, I mean, if we were to say, sure, you can impose consecutive sentences, what is a trial judge to do on remand with that when knowing that cannot impose a greater sentence?
I think they would know that the overall sentence still can't be greater than 45 years, but how that is divided up between the two charges would be free to, hopefully the court would order that a new judge be assigned to the case. That new judge would be given essentially carte blanche for 45 or less, depending upon.
In this case, the trial judge said, A, I don't think I can do it, but he also said, I wouldn't do it anyway, even if I can.
Well, I think the important part for this court to decide is whether or not he had the legal ability to do it.
Yes, but if he says that even if I can, I wouldn't do it as a matter on these facts, doesn't that take care of that argument?
I was hoping more for the court to give guidance to future judges that they had the.
We don't usually issue advisory.
I understand that, Your Honor.
Well, in this circumstance, isn't it discretionary as to whether or not the judge would decide to impose consecutive sentences pursuant to the statute?
Oh, 100% is discretionary. I'm not saying it was an abuse of discretion for him to do it. What I'm saying is he got the law wrong when he said that he could not do it. But I concede to Justice Stanfield's point that he then said, even if I could, I think he said I probably wouldn't, or that he would give a greater sentence. So I don't think he was as definitive as Your Honor was saying.
Well, he went on to say reasons why he thought it was a bad idea.
I agree with that, yes.
And he felt constrained by the statute.
I'm sorry, I didn't.
He felt constrained by the statute?
Yes, he said he believed he could not do it as a matter of law.
So as we know under the statute, sentences must be concurrent, except the court may impose consecutive. And the only subsection really that would apply here is that the convictions are for offenses based on different conduct arising from different criminal episodes.
Yes, and in this instance, there were two different victims, there were two different weapons, there were two different crimes.
All occurred within seconds of each other at the same location by the same perpetrator with the same motivations?
And I would point to this court's case, which happened to be mine, State versus Stanley Ward, where there were similar facts, but one victim, and the court said it was acceptable in that case.
Let's say we agree with you that the obituary should not have been read into the record and that the psalm should not have been read at the end. Let's say that we agree. Given that you apparently can't point to any fact in the obituary that wasn't presented during the family's remarks, and given that the psalm was read after the court had rendered a decision, why aren't both errors, assuming they were errors, why aren't they both harmless?
I think that they are harmful to the perception, to the public, to the defendant, to defense counsel, that it undermines the independence and impartiality of the judge.
But assuming we agree with you on that, why should the sentence be vacated?
Because the only way to reverse that feeling of uncertainty that the proceeding was fair is to give a new proceeding. It was so, again, it was a violation of the judicial canon. It shows a violation, it shows an appearance of bias. It undermines the public confidence in the proceeding.
The judicial canon isn't specific, but doesn't it really go to adjudicative facts? We're not talking about adjudicative facts here. We're talking about sentencing facts.
Well, I don't think that I agree that the rule is not specific, but I would say it applies to sentencing facts because ultimately, that is equally as important for a criminal defendant as a trial fact.
Well, and in this case, the judge specifically said, I also obtained a copy of the deceased obituary, which was very moving to me. So the court not only said, I looked at the obituary, but indicated it was affected by the obituary. Does that have an impact on your argument?
I see where Your Honor is leading me, and I'll say yes.
Well, yes. Well, it is a surprise.
So I appreciate the assist there. Yes, I would say it would, and it's also disturbing that it wasn't given to either party even in advance so that we would be prepared to how to respond to a comment like that.
Well,
But
how should we take the fact that the judge, before reading the obituary, does two things, indicates that he felt that as a part of the sentencing process to have a better idea or knowledge of the victim, beyond what information he has been provided, that he felt the need to go out and independently get the obituary and then ask the permission of the family to read that into the record?
I'm repeating myself, but I think that shows a lack of impartiality, that before he came into the proceeding, he had already found which side he was essentially going to favor and which side he wanted more information from.
And your point is that even if there aren't any actual facts in there that influenced it, by saying he was influenced by it, that he was very moved by it, by doing that, it creates an appearance of such bias or lack of impartiality that we have to vacate solely on that basis.
Yes, that was...
Well, should we infer that there are different facts in there to the extent that the court said that what it had before it, the court did not believe it was enough in terms of having a sense of what the impact on the victim was?
I'm happy to do so. The problem is when I forget which justice asked me if I could point to a particular one. Unfortunately, I cannot point to a particular fact that was not known. But certainly the judge is suggesting that that is the case. But I just cannot point to one in particular. But
And just for the benefit of anybody listening, would you just state what your motivation was, your strategy was for requesting consecutive rather than concurrent sentences?
I know that this court does not get involved with the legislature or tell the legislature generally what to do. However, I've always struggled with the idea of someone can get probation is not allowed for someone who receives a murder sentence. And in this case, Mr. Servil suffered from extreme mental health issues. He had been found incompetent during the course of the trial, and I was afraid of what life will look like for Mr. Servil if he serves 25, 35, 40 years with profound mental illness and is just released onto the street without any level of supervision. So
you were hoping for services after his release from prison?
I thought for not just for Mr. Servil's benefit, but for the community at large, and I thought there was a missed opportunity to help provide that. Thank you very much.
Thank you. Attorney Sibley.
Thank you, Chief Justice Stanfill, and may it please the court. Any error in the sentencing of Jason Servil was harmless for several reasons. First, the information contained in Alice Abbott's obituary was substantially similar to the information already presented to the court. For example, the obituary described Alice as beautiful, having a smile that could light up a room, and that she was especially looking forward to the birth of her nephew. Orally and prior to reading her obituary, the Abbott family had described Alice as having a beautiful, motherly personality. She made life bright, full of surprises and fun, that she was the first person told about her brother and sister-in-law's pregnancy, and described her excitement about being an aunt. Thus, the reading of her obituary did not generate any new facts on which the court relied in imposing sentence on the charge of murder. Second, the court's reading of a brief psalm occurred as part of the court's closing remarks, specifically directed towards the Abbott family and after the sentences were imposed. The remark was directly responsive to the belief system expressed by the Abbott family during sentencing, It was intended to reassure them that their faith would help them through the grieving process and provide them with, as the court said, some level of solace concerning their unimaginable loss and their clear displeasure with the partial plea agreement. And finally, it was intended to calm the highly contentious atmosphere in the courtroom. Finally, Maine law does not mandate that the court impose consecutive sentences. Given the facts of this case, including premeditation, 2 victims, 2 different weapons, and committing a murder after an aggravated assault, had the court chosen to impose consecutive sentences, it would have been well within the court's discretion to not impose a fully suspended sentence as proposed by Servil. Therefore, the court's decision not to impose the consecutive sentences was ultimately to Mr. Servil's benefit, and I'm happy to take questions at this time.
Let's go to the issue of the obituary. Assuming you're correct, and I think you probably are, that it didn't really introduce adjudicative facts into the proceeding that weren't really already there. In this case, the judge said on the record, turning to aggravating factors, in discussing the aggravating factors at step 2 of the analysis, that aggravating factors to be considered include the subjective effect on the victim. I think that part of the sentencing process should involve some knowledge on my part of the victim, in addition to everything I have been provided. I obtained a copy of the deceased obituary, which was very moving to me, and which, with the parents' permission, I would like to read that into the record. Doesn't that very clearly state, I thought I should go look it up on myself, I found it moving, and I am finding this to be an aggravating factor?
I will start with, I am not going to stand before this court and say this was best practice on the part of the sentencing judge. This was in the context of considering the subjective victim impact holistically, not just the victim who, as the court said, paid the ultimate price, but also the victim's family, and this court has recognized that subjective victim impact is an aggravating factor to be considered in these cases.
Don't we have an obligation to ensure that the proceeding has the appearance that it is free from bias, free from prejudgment, and free from partiality on the part of the judge?
Sure, we should always endeavor to make sure that all of the proceedings, whether they be sentencing or trials, be impartial and unbiased. I respectfully disagree with my colleague, Attorney Pratt, that this was a giant signal that the sentencing court was just completely on on the state side or the victim side and discounting any information towards Mr. Servil. Again, it is not best practice, but there wasn't anything additional that the court.
Well, you say that there wasn't anything additional, but the court seems to suggest in its statement that there was something additional that the court found particularly moving. And if you go through the obituary, there are things that are mentioned about activities that she engaged in and things that she did with the family beyond anything that was set forth in any of the statements that were made to the court.
I believe a lot of them were also made to the court as well, and unfortunately both of us don't have the ability to be sitting in the courtroom or to be inside the judge's head to know exactly what it was that the court was referring to.
And that's why we have to go by his words, that he found it moving.
Correct, Your Honor. We are at a disadvantage because, like anything, the moving could be one way or the other. We're just stuck with a word on a paper as to what he meant by moving.
But he made that statement in the context of considering the aggravating factors for sentencing purposes.
Of the subjective victim impact, which is the appropriate consideration. And I believe that the transcript kind of bores this out, that it's considered holistically as part of the subjective victim impact because directly after doing so, the court then goes on to say another aggravating factor and then continues to move through the analysis.
Let me ask this question. If we assume that there were differences between the obituary and the other information the court had received, and that impacted, as the court said, moved the court and impacted its approach to assessing the victim impact, was that impermissible?
Again, it really would not be best practice, Your Honor. I think it's not what we have presented in this case, and as Your Honors know, I try to avoid hypotheticals, but it could potentially be a very different situation if we were talking about material differences, not only in the facts, but certainly material differences rising to a level of prejudice. For example, the cases cited by Mr. Servil, the Di Giovanni case, where the court actually generated new facts that favored a party, then reopened the hearing for the party to present that, and then ruled in favor of that party. That is not the situation that we have here.
No, it's not
Does it have to be a new fact? In other words, the transcript suggests that the court's perception of victim impact was enhanced by its review of what I think you're conceding was an impermissible source of information.
Well, it's certainly not best practice, but I wouldn't say that it really enhanced it to a level of rising to prejudice or reversible error. In the context of this entire record, if this court says this is an error, it's certainly not best practice. I don't think it's harmless on the totality of this record.
So would you have us issue a decision that says, well, it's not best practices, but judges can go ahead and investigate on their own, just as long as it doesn't really, rock the boat too much? Would you endorse a decision like that?
Not investigating on their own, which is why I tried to draw the distinction with at least the Di Giovanni case. This is, and then I believe the other one is Vent, where the independent research was used to impeach Mr. Vent's primary witness. This does not rise to that level.
Did any of the cases cited by Mr. Pratt involve sentencings, or were these all cases that involved adjudication?
There was, I believe it's, I cannot remember the beginning of it. It's the Patno case where that was a sentencing, and that case really highlights the difference as to what occurred here. In that case, the defendant was convicted of sexual abuse of a male minor. During the sentencing proceeding, the judge read a rather lengthy biblical passage directly aimed at condemning homosexuality, and then followed it up with saying, based on the circumstances of this case and the nature of the defendant, I do this. Almost a clear link between the two. That's not what occurred in this case, either with the obituary or the reading of the psalm after the imposition.
How do we apply the standard that we utilized in Moore, where we said a sentence based in part on an impermissible consideration is not made proper simply because the sentencing judge considered other permissible factors?
Again, it's coming back to the obituary did not add anything material that was not already presented, either in writing through the victim impact statements and from the family members who spoke during the court. We are talking about information that is almost identical across the board.
So, I mean, you're arguing it's harmless because it was essentially redundant and cumulative.
That would be part of it, yes, Your Honor.
Because the obituaries do two things. They list the facts about the person who died, and I think there are no new facts that were introduced at that point. And they also reflect the loss that the family is feeling. And there was abundant evidence, wasn't there, about the loss that the family was feeling other than the obituary that was properly included in the record?
Absolutely, Your Honor, especially in the transcripts. It really jumps off the page how displeased the family was with this partial plea agreement, and really the extremely significant impact on their lives. Her brother talked about how he's completely lost a part of himself. Her sister-in-law talked about how a piece of her husband is gone, how this crime sucked all the joy out of their lives regarding their pregnancy. Her mother talked about
And
how
all of,
now
the, all,
she
of that was, all of that was true, but again, I keep going back to the fact that the court was not dealing with the victim impact statements at that point. It was talking about the subjective impact upon the victim, period. Not the family, the victim. And the court said that it found information in the obituary that it found moving. Presumably, if the court is making those statements in the course of the sentencing process, that would suggest that there was some information that was above and beyond what had been contained in the statements that the court had already received, which it noted when it said it went and looked for the obituary, does it not?
That could, I would argue to this court that that was really kind of a verbal misstep on the part of the court, because the court really, when you read.
But all we can work with is what the court put on the record.
But when you,
And that's the issue, right? How it appears. It is the appearance of whether there's an impartial tribunal that is a concern.
correct, but when that part of the transcript is really read as a whole, what follows the obituary is the court discussing all of the subjective victim impact, discussing, you know, how all of this grieving has been presented through the court, and I believe the court specifically cites both stuff that, information that was submitted in writing, information that was provided orally, and then, so there's the recognition of the family, and it's only then that the court says, and I'm supposed to recognize this just beyond Ms. Abbott, who paid the ultimate price. So could it have been articulated better, more clearly for our purposes? Of course, but this was all done considering subjective victim impact.
But this isn't just an articulation. This is, I went and got the obituary.
Which again, is not best practice.
Well, and it was also an error, wasn't it?
Knew that question was coming, Your Honor. It is up to this court to tell us whether it is an error or not. From my perspective, at the very least, it is not best practice. Thank you, Your Honor.
Thank you. Attorney Brett, yes?
I didn't want to be presumptuous, Your Honor, so.
Oh, no, I expected you to go right up.
I just would like to briefly correct one thing that Attorney Sibley said, which I think she suggested that I had said, and maybe I did, and if I did, I apologize, saying that clearly based on the conduct by the judge that he was either biased or prejudiced towards the defense or to the defendant. What I meant to say, and what I would like to clarify by saying, is he gave the appearance of being not being impartial. I would point out to this one case, which was from Deutsche Bank, Lyle versus States. It's on page 14 of my brief. It says, the court wrote there, whether intentional or not, the trial judge gave the appearance of partiality by taking sua sponte actions, which benefited one party over the other. I would say this is exactly what happened in this case. That was the sentiment that I was trying to express. And again, I would say it undermines the public confidence in an impartial tribunal. And I would ask this court to reverse and make a finding, a holding that any outside research will result in a reversal. And I would ask this court to order that a new judge be assigned to the case. Thank you very much. Or I'm happy to answer any questions if the court has any. Thank you.
There don't appear to be any, thank you. All right, counsel, as is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. And with that, we'll be in recess on this matter.
All right.
matter before the court is PUC 24-322, Snake Root Solar versus Public Utilities Commission. And we are being streamed live on the web, both with video and with audio. If counsel would identify themselves by saying their names for the record, together with the party they represent, starting with appellant.
Jonathan Donitz on behalf of Snake Root Solar LLC. With me is co-counsel Hans Eisenbach.
Dea Taylor on behalf of the Maine Public Utilities Commission. Next to me is Liz Wyman, my co-counsel.
And Brian Marshall for the Office of the Public Advocate.
Thank you. And Attorney Donitz, if you're ready to proceed.
Actually, can I make a disclosure?
Oh, yes, I'm sorry, one more matter. Go ahead.
I just wanted to disclose, I own stock in an energy company called NextEra. I don't think they're parties to this case, but I know in the energy industry there are conglomerates and investments and overlapping relationships. So if counsel are aware of NextEra having any role in this, I'd appreciate it if you jump up and tell me now. I'd also appreciate it if talking to your clients after the fact to see if they're aware of any involvement. And if that's the case, please notify the clerk and I will recuse from the case. And if any of your clients or constituents have any particular concerns about my involvement in the case, by the same token, you can pass on any requests for recusal to the clerk and he'll pass it on to me and I'll recuse. And that would be anonymous, so I wouldn't know who it was that was making the request. But the footnote to that is I welcome anybody advising me of potential conflicts. There's no demerits to that at all, but any requests would be anonymous. So I'll just ask at this point, are any counsel aware of NextEra having any role in the case at this moment?
We are not, Your Honor.
Okay, and you'll talk to your clients about it after the fact. All right, thank you, Chief.
Yes, Your Honor.
Attorney Donitz.
May it please the court. Jonathan Donitz, an attorney with Servil, Dana, here on behalf of appellant Snake Root Solar LLC. With me at table is my colleague and co-counsel Hans Eisenbach. In 2019, the Maine legislature amended the Net Energy Billing, or NEB statute, to permit renewable energy projects of up to 5 megawatts to participate in the program. 2 years later, the legislature took the extraordinary step of changing the rules by creating new milestones for projects and attaching deadlines to those milestones. These new deadlines, some of which were retroactive, were imposed after Snake Root and other developers made significant investment and signed contracts with CMP and Versant based on the 2019 NEB expansion. The legislature clearly recognized the severe implications of this mid-game rule change and its impact on those who proactively develop projects after investing in Maine in reliance on the 2019 amendments. Specifically, when the legislature added the deadlines, it also included a provision that permits projects that miss a deadline to apply for a good cause exemption. Pursuant to that provision, a project that misses a deadline can petition the Commission for a good cause exemption where the deadlines are missed due to external delays beyond the project's control and without which the entity could reasonably have expected to meet the deadline. Unfortunately, the Commission has never established a clear standard for when it will grant good cause exemption, nor has it articulated a standard that applies the plain language of the word delay. There was no rulemaking, and the Commission's decisions provide little guidance on what does or does not qualify for a good cause exemption. Sometimes procurement delays do qualify. Sometimes similar procurement provisions do not qualify for good cause. Some interconnection mismanagement will qualify for good cause, other times it does not. Based upon the dockets that have been decided to date, it appears that the Commission's standard is that it knows good cause when it sees it. It does not, however, pronounce an actual standard upon which projects can rely. This leaves developers without any understanding of how good cause may apply to their particular circumstances. Similarly, it provides this court with no understanding of how the Commission exercises its discretion. And understanding how the agency exercises its discretion is an important factor because this court held in Central Maine Power v. Public Utilities Commission, 436 A. 2nd 880 at 885, deference to an agency is not a toothless standard. That deference yields to the legislative intent in an unambiguous statute. Of note, Applying a know-it-when-it-sees-it standard, the Commission essentially has written delay out of the good cause standard by never affording it the plain meaning. Here, there were numerous delays. CMP originally said it would take about a year to interconnect this project. It took...
So I see the green light is on. You said there's no clear standard for the word delay. You left out another word in that sentence, or in that statute, which is external. Your position is that the statute's unambiguous, correct? The Commission's position is the statute is unambiguous, correct? Isn't that the definition of ambiguity? And I'd like you to focus on the word external. What does external mean to you?
External means that it was not the project's, it was not anything that the project did or the developer did that caused that delay. So it's external to the project. So if a procurement delay occurred, or if CMP or Versant took longer to interconnect, that's external to the project.
So what you're saying is more delay than you expected, then that becomes external delay? In other words, doesn't Snakeroot have to know as a developer that there are, frankly, delays that happen in these kinds of projects? And it seems like what you're really saying is, well, yes, but it was, you know, not us, it was CMP on the, with the Cluster 6 study, and that it was basically more than you expected.
It was far more than what was expected, but it's a delay in the process. The process would normally have taken about a year. This one took well over 2 years.
But this is not a process where you were given at the beginning of the project deadlines, like we will have this study done by then, or we will do this by then, or things like that from the external partners that you had to work with, and you knew you had to work with external partners.
We knew we had, the project knew it had to work with other partners, but this cluster study was far longer than any cluster study that had occurred up until that point. This cluster study took far longer than could possibly have been expected. During the process, ISO New England changed the standards.
But I'm finding your argument so interesting because it seems like you're going back to exactly what you said the Commission shouldn't have done, which is the foreseeability of the delay.
Well,
You're saying it's longer than you expected, and that it was too long, it wasn't foreseeable from Snakeroot's point of view.
But even if you apply a foreseeability test.
Right. My confusion is I thought you were saying we shouldn't apply a foreseeability test.
Can I add another layer to that question? Obviously, your client ran into a cascading series of stuff that happened in the meantime that made things ultimately impossible. But the PUC granted Pembroke a good cause exception, and they hinged it on the fact that there was a rather extraordinary 81 weeks to wait for a component, which was longer than what was anticipated coming through the door. But, and this is what I'm adding to the previous question, PUC found that Pembroke had all its ducks in a row. Everything else was done. They were ready to start on day one, except for this one little factor, whereas your client still had invoices that hadn't been received, payments that hadn't been made, and were not nearly ready to start on day one.
Snakeroot had procured everything except for inverters. They hadn't paid because they hadn't been invoiced by CMP yet. Again, beyond their control. They can only pay the invoices that they're paid.
But could they reasonably have been expected to meet the requirements, but for the circumstances that landed on them?
Yes, Snakeroot, and the record below shows that Snakeroot expected to have been ready to interconnect by October of 2024. But for the delays that were beyond its control. And Pembroke is an interesting case because in Pembroke they said that the procurement delay was a reason to grant good cause. In this case, they said, well, by 2024, procurement delays were such a part of the process that you could expect that. So if you keep moving what's expected further down the line, there can never be delay. So a procurement issue in 2024 that did not exist in 2020 is a delay.
This process obviously is a long and protracted process in the best of circumstances. I want to come back to the statute, though. If it is ambiguous, then would you agree that our jurisprudence suggests we defer to the agency? And isn't this a purely discretionary call on the part of the agency?
I would disagree that it's ambiguous. If it is ambiguous, yes, the discretion.
I want to suggest to you that the phrase external delays outside of the entity's control could mean one of two things. It could mean external to snake root, or as the commission is arguing, it could mean external to the process. And we're talking about a process that everybody knows, including the legislature when they passed this statute, that there are numerous opportunities for delays in this process. And the whole purpose of the statute, of the amendment, was to sort of curtail the gold rush, as I understand it. They wanted to kind of protect the ratepayers. This is what the commission is arguing, and the public advocate. They wanted to protect the ratepayer from too many developments happening. So I want to come back to the statute's language, because that's important here. External delays outside of the entity's control. Aren't all external delays, so to speak, outside the entity's control? What external delays would snake root control? So I'm suggesting that just by the plain language of the statute, there may be an inconsistency in your argument here.
Well, external control, I think external is clarifying beyond the control. So it's delays that can't be controlled by snake root, such as the study, when they're invoiced for projects, and here, importantly, this was the first project in the queue. They can't control who comes in after them and how many projects want to interconnect at the same substation. So in this case, when snake root applied and paid their initial payment, they were the first one in the queue. They had a reasonable expectation that they would be connected within a year.
So your interpretation of external delays carries with it a degree of culpability, I'll say, for the delays. They didn't cause the delays, and they couldn't control the factors that resulted in the delays, that they had no culpability in why things got delayed.
Well, I don't necessarily want to put culpability on this, because it's not really a statute that involves fault. Like, if CMP had a delay for reasons beyond its control, that's still a delay. So it's
How
not
about if I substitute did something for culpability?
Yes.
Okay.
Well, the commission in its brief suggests that snake root hasn't paid CMP for distribution or transmission costs, has made a partial payment for the distribution upgrade costs. The suggestion is that snake root could have done more to expedite completion than it has done, because it hasn't paid CMP to do the preliminary work that is necessary.
Snake root didn't make that payment because it wasn't invoiced by CMP, and it wasn't invoiced by CMP because CMP asked for a waiver, excuse me, of a regulation, or of one of the regulations that set a deadline for when payments had to be made. And CMP asked for that extension because it had, for various reasons involving the interconnection process, it could not send the invoice.
Could the legislature have passed this statute without a good cause exemption? In your opening, you noted that this has retroactive effect. What if they had not included the good cause exemption?
If they had not included the good cause exemption, I suspect that we would not be here, although it's entirely possible that snake root would have perhaps had a takings action or the like.
But they did pass it, and they did amend the statute, and they used specifically the word may. The commission may grant. So even if you meet the requirements, does the commission then have the discretion to deny?
Even if it does have that discretion, it needs to set some sort of standard that the projects can rely upon. Here, there is no set standard, and it differs from project to project and from good cause petition to good cause petition. Again, we have an instance where...
It seems like the standard you're arguing for is if someone that you have to work with, whether, and this project obviously depends on a lot of whether it's suppliers, whether it's CMP, et cetera. If someone that you have to work with takes longer to do something than you thought it would, that's an external delay beyond your control?
If it is somebody from the non-snake root side of the ledger, yes.
So anything that takes longer than you expected is an external delay beyond your control, as long as it wasn't snake root that took longer.
Correct, Your Honor. I see my
All right,
time
thank
has
you.
expired.
Counsel?
Good morning. May it please the court. The commission in this case received what it believed to be a directive from the legislature to limit the number of NEB projects in the interconnection queue and sought the most objective way to carry out that directive. The result is an order that is lawful and based on the substantial evidence in the record. I welcome any questions from the court at this time.
Is it the commission's position that even if snake root met the good cause requirements here, external delay beyond their control, but for which they would have made the milestone, is it your position that the commission would then still have the discretion to deny an application?
The commission would still have the discretion to deny that petition. However, the commission would have to still issue a decision that was based on the factual record and didn't result in an arbitrary and capricious.
What standard would you be using then?
I wouldn't want to speculate on the standard that the commission would use in that case. To date, we have not exercised our discretion in...
Isn't that the essence of arbitrary and capricious?
To date, we have looked at the facts of all cases and determined them on the merits of the facts presented in each case.
But aren't you actually imposing an additional requirement? I mean, in this case, there's no question the snake root didn't do anything to cause how long it was taking CMP in the cluster study. You agree with that?
Correct.
So in that sense, it was not in their control. You agree?
We agree to a certain point, I would say. The record does point to maybe some things Snake Root Solar could have done. As the justices have brought up, they only paid part of their interconnection payment.
But that has nothing to do with how long of the cluster study was taking. That has to do with whether the second part of the test, right? Whether the entity, even without the delays, could reasonably have been expected to meet their requirements?
I think in this case, correct. It's very clear that the cluster study itself was outside of Snake Root's control.
So the cluster study was done by somebody external to Snake Root, and they didn't have any control over how long it takes. Why is that not an external delay outside of their control?
In this case, the commission found that it really sees an external delay as something that is external to the normal and expected.
So aren't you really reading in different requirements, aside from whether you can or not? You're really reading in something additional here, that it has to be an external delay that's essentially unreasonable, unforeseen, or something like that.
In this case, the commission is not applying a strict foreseeability standard. It doesn't expect projects
Well,
to
how are you defining the delay, external delay?
something that is external to the process.
Yes, which this was.
Something that is completely...
Well, was this external to the process? My understanding of your argument is that the cluster study process itself, or the transmission impact study process, is part of the process. It's an internal part of the process, just as is the construction scheduling that CMP eventually produces. Those are internal to the process itself. That's my understanding of what you're arguing.
Yes, I guess I must have misunderstood the
then
question.
I'm sorry, I misunderstood. So are you then, but it seems like you're imposing an element of unreasonable delay or unexpected delay in here, not just any, the statute doesn't say that. It just says delay.
The commission applied a standard that looks at the entire interconnection process. As the justices earlier recognized, the process of interconnection can be an incredibly difficult process. It can become extremely protracted. You always have to work with other people.
I understand all of that, so my question is really kind of simple. How are you defining delay? If I am a developer who says, I need to make a decision on whether to apply for a good cause exemption, I want to know what the standard is. They've obviously said, well, it's not every single delay. It's not every time something takes longer than we thought it was going to. So what is the definition of what is an external delay that may justify an extension or a good cause exemption?
So in the case of the good cause exemption, the commission has granted 19 good cause exemptions. And the cases in which the commission has granted exemptions are cases in which oftentimes a project was giving very clear information. Something went completely opposite of the clear information provided by either the utility, by ISO New England, perhaps another entity they were working with.
So are you reading in the word unexpected, external unexpected delay?
I think
I'm still looking for a definition here.
I don't think the commission would fully see it as unexpected. There are instances where the commission might see the word, might imply that it has to be unexpected.
Okay, so how are we supposed to understand what the standard is that the commission is applying?
The commission is applying a standard that, an objective standard that requires each developer to take the information that it has in front of it and make reasonable and informed choices about their project. If they are looking at the interconnection process and they receive information that says, hey, you're not going to be online, or you're not going to receive something by the time that you think you're going to get these things, then, and they continue and plow on with the process, unsure of
I feel like you're still not answering my question as to how I'm supposed to understand what an external delay is that would justify an exemption. I'm looking for a definition or a standard.
The commission has applied an objective standard that, again, looks to the process, looks to the information that a developer was given, and
decides what?
And decides whether or not that developer reasonably moved through the interconnection process and made good decisions for their project.
So are you saying that the reason it was denied in this case is because Snake Root didn't move appropriately through the process and didn't make good decisions? Is that what the standard is under this exemption?
Snake Root moved through the process. It was given information at multiple points during the cluster study that its project may be in danger of not coming online by the statutory deadline. And yes, it continued to move through the interconnection process.
How does that fit in with the statutory language? I'm really actually a bit confused.
I guess if we could narrow down this question.
Can you give an example of an external delay in the commission's view? It would be something that I'm suggesting or asking, I guess. Would it be something that an event that occurs that is not part of the ordinary, usual interconnection process? The impact study is part of that process, as I understand your argument. The procurement schedule is part of that process, but if some other external event occurs that is something that the developer has no control over, that's what we're sort of looking for. What is that external event?
So the commission, in our cases, we've granted exemptions where, say, the interconnecting utility failed to provide important information, maybe about nearby interconnecting projects, maybe they did not maintain Chapter 324 interconnection deadlines as tightly as they were supposed to, something in which the developer should be able to rely upon.
What about the situation where there are events occurred that maybe could be anticipated, but it's a perfect storm of one thing happening after another, that just dominoes falling over. Is that something where the PUC would say, yeah, okay, those maybe you should have anticipated them, but this is a crazy situation, perfect storm, we're going to give you an exemption?
I think the commission would take the facts of that case and look at each individual domino as it fell and not judge the totality of the dominoes until it understood what the effect of each domino in the line.
Sounds to me as though the commission expects developers to take into account in their planning external delays that are common and typically associated with the process, and that an exemption could be granted when an external delay is extraordinary in its length, so that the developer could not be held to have anticipated it. Is that a fair summary of the commission's standard?
So long as the developer were able to prove that it acted reasonably, so long as the developer was able to prove that it did everything that it could to keep its project moving forward. I see my time is up.
It is. Thank you.
Thank you.
Attorney Marshall.
Good afternoon. May it please the court. I'd like to pick up on a point that Justice Douglas made. The NEB law says that the commission may issue a good cause exemption if it finds that the statutory criteria are satisfied. Now, the legislature has defined what
But when we talk about the exercise of discretion, assuming it is discretionary, that it still has to actually be exercised, and it has to be done considering all of the factors. And it's not just, you can't just randomly say, yep, today we don't feel like granting an exemption, right? I mean, you agree with that?
I agree that it can't be a truly arbitrary exercise of power, but I think what this court said in Friedman versus Board of Environmental Protection is that that word may is significant, and it means that, you know, essentially this decision is committed.
Yeah, but in Friedman, that had to do with whether to take corrective action, essentially, that kind of prosecutorial or executive function. That's really a different situation, isn't it?
I would disagree with Your Honor in part. At issue in Friedman was the modification of a license, not the enforcement of that license. And the statutory scheme was very analogous to the situation here. It said if the agency finds that certain criteria are met, the agency may take certain action. And that's exactly the structure of the good cause exemption law.
It's not an absolute exemption. Are you arguing that the use of the word may, conferring significant discretion, should influence our review of the commission's actions?
Absolutely, because even if the statutory criteria are satisfied, there is no legal obligation on the agency to grant a good cause exemption.
You may regret that argument later
What
on.
do you define as external? What's an external delay?
I would define external, and I think it's ambiguous, going to some of the questions you said earlier, which I think that means you defer to the PUC's reasonable interpretation. You know, my thought on external is that it's outside of the process. When we're talking about a cluster study, that's something that a developer expects to encounter, at least in Maine, as part of the interconnection process. And there's no hard and fast deadlines with that process. It depends on the number of projects that are in the cluster. It depends on whether projects drop out. It depends on whether projects...
So I think what I hear you saying is you're answering the question I was asking Attorney Taylor, which is that what has the commission essentially grafted onto that phrase so that we understand how they are defining external, and you're saying it has to be external to the process as opposed to one of the, I'm calling them partners, but whatever you want to call it, the necessary people involved, the CMP, taking longer than you thought they were going to do.
Yeah, there's a couple important words there. So one is external. What does that mean? I think it means outside of the, you know, the process itself. The other is, what does delay mean? Just because a process takes a long time, that doesn't mean there's a delay. And as the commission points out in its order, there's never a deadline given on these cluster studies.
Well, isn't part of the process here that when Snake Root went into this endeavor, that process in terms of the cluster studies were still being adopted by the PUC, or being adopted in this process. And so that was evolving as they were attempting to get their project through. So how could they, They talked about having a reasonable expectation of getting their project through to fruition in a year's time. But how could they know that to the extent that the process was involving that they were engaging in?
That's a fair point, Your Honor, but I think, again, going back to, there's no foreseeability element in this test, right? And this is an unprecedented law, this NEB expansion, so it makes sense
But there
that-
really is some foreseeability in there. If you're going to define delay as being either taking longer than expected or unreasonable, all of those things involve essentially tempering it. I mean, defining the word delay, doesn't it?
I don't think so, Your Honor. I think you can define delay as you had a deadline and that deadline was moved, and you just don't see that.
So absent a deadline, there can't be delay?
That is a reasonable interpretation of that statute, and I think that is what distinguishes some of those cases. So going back to the Pembroke case, which was raised earlier, there was a construction schedule with a 2024 commercial operation date in that case. The developer made their interconnection payments in reliance on that construction schedule. After that, the schedule was amended, in other words, delayed, and
But they had a component that was going to take much longer than expected to arrive. Can I ask you in the last 20 seconds you have on your time here? I think I heard you say that external meant external to the process. Was that? But as I read that there's some modifiers that follow that due to external delays outside of the entity's control. Doesn't external refer to external to the entity's ability to control? It doesn't say anything about the process. It just says if the entity can't control it, that
You may answer.
qualifies.
Yeah, I would say to give effect to all of the language in the statute, then external has to mean something other than, outside of the entity's control. Otherwise, it's just superfluous. So I do think those two clauses have independent meaning.
Thank you. Attorney Dunitz, you reserve some time for rebuttal. Okay. All right, then, as is our usual process, we will take the matter under advisement and issue a written decision in due course. It's also my understanding that Attorney Taylor, this is your first argument or your first appearance here in front of this court. And as is our usual practice, we invite all counsel in the well to come back and take the greetings of the court.
All right.